G'day everyone, and welcome to week 11 of our course in Legal Ethics and Trust Accounting. So far, in general terms, we've talked about the practitioner's duties to the court, we've talked about a practitioner's duty to the client, and we've talked about practitioners' duties towards one another. This week, we're going to take all of those duties and apply them to a very specific context, actual courtroom proceedings. By now, you're well aware that for most practitioners, most of their work happens outside court. But court itself is special. There are particular rules that you need to know and follow. This week we have 5 videos. In this first one, we'll look mostly at the duty of formality. In the second video, we'll talk about forensic independence, which is the idea that when appearing in court, a lawyer is not merely the mouthpiece of their client. In the third video, we're going to talk about the responsible use of court, and in particular, responsible approach to cross-examination. Then in the fourth video, we'll focus on witnesses. We'll focus on preparing witnesses to give evidence and communicating with witnesses. In the final video, we're going to take half a step to the left and look at some specific duties that apply to prosecutors. Before we get to any of that though, we need to go right back to week 2 when we talked about the different sources of ethical rules. Back then I mentioned the barrister's rules. Barristers, of course, are practitioners who are specifically focused on court. They spend a lot of their time either preparing for court or appearing in court. And so when we talk about ethical rules that apply in court, we're suddenly much more focused on the barrister's rules. Having said that, the days when barristers were really the only ones appearing in court, well, those days are long gone. More and more we're seeing the rise of the solicitor advocate, solicitors who specialise in courtroom work but who remain as solicitors rather than going to the bar. And so the solicitor's conduct rules also contain rules for advocacy, which are very consistent with the rules binding barristers. This week we're going to refer to both. We start though with the fundamental notion that everything we do in court is first and foremost done in order to help the court do justice. The underlying premise of our judicial system is that the court and the judge are there to do justice between the parties, and their capacity to do justice is enhanced when each party is represented by an advocate who advocates hard for their party but within the rules. When appearing in court, you are not simply there as some sort of gladiator on behalf of your client. You're there to help the court do justice. Anything that you do, any tactic that you exercise that makes it harder for the court to do justice, that's ultimately likely to backfire on your client. On the other hand, the more that you can do to assist the judge to do justice, the more you help the court and the more likely you are to help your client if your view is that the justice is on your client's side. And of course, if you don't hold the view that justice is on your client's side, then you should have clearly advised the client that this is the case. The justice of a case is not likely to be fooled by legal trickery, no matter what you might have seen on TV. So, our opening headspace, if you like, is to assist the court to do justice. Our first duty in this regard is the duty of formality. Court is an important place. Important things happen in court. Lives are changed. Laws are changed. Sometimes society is changed. Australian culture tends towards the casual rather than the formal, but this is not carried over into the courtroom. In Queensland, barristers and judges still wear wigs and gowns. Solicitors are required to appear in court in a business suit for men and an equivalent level of formality for women. You still refer to the judge as Your Honour. You refer to other court officers by their title, the registrar, the bailiff, the associate. You adopt a formal register in your tone of speech. Why do we do all of this? Is it just to somehow emphasise the importance of the occasion? Is it some sort of peculiar system of dress-ups? Is it merely tradition? Does it have any practical value? Well, it does. The practical value is this. When a judge sits on the bench, they are not sitting there as an individual human being. In our system of government, one human being is as good as another. No individual has some sort of elevated status that allows them to pass judgment on others. Even judges are not special. But when they sit on the bench, they cease to be that individual. Instead, they become the embodiment of the law, the embodiment of the crown. Even when the law requires them to make a decision that they personally disagree with, they will do their best to apply the law. They will apply laws that they personally regard with contempt. Because on the bench, they're not Michael Kirby or Mary Gaudron. They're Justice Kirby and Justice Gaudron. And when they pass judgment, they're not doing it personally. They're doing it in the exercise of their duty. If they find against us, we have no cause for personal animosity. They as an individual haven't found against us. They are an officer of the law, and they've found that the law is against us. Formality in court allows us to traverse very difficult conversations and disputes without ever resorting to personal rancour. It matters. There's one particular expression of the rules of formality that I want to focus on, and that's the rule against familiarity. Solicitor's Conduct Rule 18 says a solicitor must not deal with a court on terms of informal personal familiarity, which may reasonably give the appearance that the solicitor has special favour with the court. Barrister's Rule 44 is set out in precisely the same terms. You see, everyone must be equal before the court. Court is not a networking exercise. Even as an undergraduate student, you're quite likely to occasionally have the opportunity to interact with a judge. They might, for instance, come to your campus and give a speech for the Law Student Society, and you might have a chance to chat with them afterwards during afternoon tea. That's all very proper. But if you then appeared before them in court, it would be most improper for you to speak with them in any sort of a familiar way. It would especially be improper for you to say to your client, we'll be fine in this matter. I know the judge. There are countries around the world where justice works differently if you know the judge. It's a terrible thing, honestly, a terrible thing. Now, the other aspect of formality is to very carefully remember that all of the other duties that we've discussed in earlier videos continue to apply in court. So, for instance, the duty of candour applies before the court. The duty to be courteous to your opponent still applies in court. The duty to follow your client's instructions still applies in court. If you just keep in mind that the court is a place of special importance and the judge holds a position of special responsibility, and if you're just guided by that sense of importance, you'll be okay. So that brings us to the end of the first of 5 videos for this week. In the next video, we're going to talk about the need for what we call forensic independence in court. See you there.